Oh. All right. Good morning, everyone. We'll give everyone just a moment to log in here, and we'll get going this morning. I see we have both Emily and Kathleen on. And from what Sarah told me, Sean is ill.
Yeah.
That seems to be going around right now. I don't know what the deal is, but I'm going to stay in my office. I'm not going to interact with anyone. So, well, good morning, everyone. My name is Andre Hargrave, and I am the director of the Minority Business Development Agency here in the Rocky Mountain region. And today we're going to be talking with the U.S. Patent and Trademark Office on some pretty interesting things. A lot of small businesses, give you an example, a lot of small businesses that come to our office don't exactly know why they should protect their intellectual property or any of those kind of elements. So this is going to be a pretty good, interesting call because we should all protect our logos, our images, and all of those kind of things are copyrighted material. But I am not going to steal their thunder because I'm not smart enough. So I'm going to turn it over to Emily, and from there, Emily, you have the floor.
Excellent. Well, good morning, everybody. My name is Emily. I am a primary examiner, which means that I am able to examine patent applications. You guys should see my screen. I'm just making sure that that's the case. We're all good. All right. So I'm a mechanical engineer by education, and I came to the USPTO right out of college. So I've been doing this for 16, almost 17 years now. So we're going to share with you a little bit about what the Patent and Trademark Office does, but also what IP is in general. So just wanted to let you know that we are giving these are personal opinions of people who work in the office. We cannot give legal advice, right? So just making sure that you're aware of that, and we're not, enforcing or suggesting too many things. We're just letting you know how the people who process your patents are told how to do this stuff. So let's start with, why is intellectual property important? Well, let's just start with that. It is property. It is something, when you apply for and receive a patent, it is property. It can be used for profit. It can be used for leveraging, suing someone. We can use it to license to other people. And we can use it, and we can even bequeath it in our will to our heirs. So it is property. Just make sure that you are aware that it is property. So that's how you would be using this in your small business, or how to make money off of this. So this is why it's important. So that it's having a defined piece of property and how to use it in your business. So let's see how it can be applied to business strategy. Well, it's attracted to investors and buyers. Mostly so, much like Shark Tank, is attractive to investors because you already have that defined piece of property. They are assisting or donating money, or assisting the small business in how to leverage that. So that's making sure that you already have the property defined, is what can attract investors and buyers. Having that property defined also deters infringements, and you can make lawsuits, or you can convince people that maybe you shouldn't be doing this anymore. We might sue you if you continue to do so. So it can get you all kinds of different things because it is property, and it is part of a good fiscally responsible business strategy. So in developing your IP strategy, you want to look at the different kinds of IP that would be applicable to your field. We can differentiate yourself from your competition using your IP, and you can grow a lot faster usually when you have that ready to go. There we go. So what are the kinds of intellectual property that are available? Well, on the left, we have utility patents, design patents, copyrights, trade secrets, and trademarks. So Kathleen and I are both utility patent examiners. What that means is we have the inventions. Not only do we get to see what it looks like, but we get to see the inner workings on the inside. So utility patents generally describe the shape of the parts, the connectors, the method steps, all of those intricate details. Design patents are basically just what it looks like on the outside. These are just the ornamental look of what the device is. So it's just like if you're just seeing it from the outside. So for instance, an iPhone would have utility patents on the procedures and your uh, programs. Those would be your utility patents, but the design patent is what it looks like from the outside and what the device looks like. Copyrights are things that are done by
Oh, did we lose her?
We might have. Emily's been having some problems with her Zoom
Yeah.
working.
Okay.
Let me hold on. Maybe that was her. I'm gonna just take over.
Okay. Do you have
I smartly left my cell phone way over there, but she was stuck on that page. I'll just go through that. Let me share my screen.
Okay. Thanks, Kathleen.
Just give me a second.
While you do that, I see that Frank has a question. Let me just see if Frank wants to talk here. I think he might be having trouble with the Q&A box. Frank, can you?
I think everyone's just having technical difficulties.
Yeah. Supposed to happen on Mondays, not Wednesdays. Frank, you should have permission to unmute if you meant to have your hand up. Looks like we're back
And
on
everyone
track.
else should be able to see my screen, which is what
Yep.
Emily stopped off at.
All right, thanks, Kathleen. And Frank, if you have a question, please feel free to put it in the Q&A box and we'll get to it as soon as possible.
So Emily stopped off at copyrights. That actually is with the Copyright Office, which is the Library of Congress. It's not actually the Patent Office, but it is part of intellectual property. So that includes things like books, photos, music, fine art, sculptures, architectural designs, and other expressions of art. They have to be fixed in some type of physical form. These are the ones where like, oh, people are like, oh, you know, the Mickey Mouse copyright is running out. It's because it's the life of the author plus 70 years. With some exceptions if their works for hire, for example. So 95 years from publication or 120 years from creation if these are works for hire. Trade secret is the one thing, oh, I apologize, is the one portion that is not regulated by the federal government. It is exactly what it sounds like, a secret. So it's formulas, methods, devices, anything you want to keep secret. So things like the Coca-Cola secret recipe, they don't release it out to anybody. They try to keep only a very select few trusted people to know it. As long as the information remains confidential and secure, it's considered a trade secret. But for trade secrets, these things could get reverse engineered, or somebody else could figure out the same formulary or the same method of what you're doing that you consider your trade secret, or it could get stolen, which I'm not going to get into that part just because it's somewhat more complicated, not in a purview of Emily and I, since we do patents mostly. And then lastly, there's trademarks, which is another intellectual property that our office does deal with. And these are basically indicators of the source of the goods or services. So you can see here, like if you see the shape of the Coca-Cola bottle down here, if you can see my mouse, you know, without even seeing the words Coca-Cola, that's a Coca-Cola bottle. Similarly, if you saw Google here, it wouldn't even have to say Google. It could just be this similar font and color combination. You probably know that's Google. These are all indicators of where the product or services come from. So that's probably one of the most important and most valuable intellectual properties that businesses have, because that's you know, their reputation, and that's an indicator of their products or what they sell. These are actually one of the few intellectual properties that do not expire as long as you continuously are using the trademark in in continuous use. And we're going to talk a little bit later, but there's two types of trademarks. There's a common law trademark where you see people put the TM next to their name or their logo, and there's something called a registered trademark, which is when you file with the USPTO for the particular goods or services in the category that you offer, where there's a circle R. So keep in mind that you don't necessarily have to have completely brand new name that other companies in other goods and services might have, as long as they're not confusingly similar. So, Dove chocolate tastes a lot better than Dove soap. They're two different trademarks for two very different products, but they have the same name. So the question is, a lot of people think, well, this is, all this registration sounds kind of expensive, like especially for patent application. It can be a long process. Do I really need a patent or a trademark or a copyright to be registered? So for patents specifically, a lot of people say, well, if I just publish or make publicly available my invention, can I just prevent somebody else from getting a patent on my invention and then suing me to stop me from using my own invention? Technically, yes, you could, but without a patent, you can't exclude others from bringing your invention to market. So that means it's a wide open space. It's like the open software where anybody can use that particular programming language to make things. Another inventor might patent the same thing if they came it up on their own and they applied before you did. And there's a few caveats there. And it might be a little bit different where your public disclosure isn't exactly what the other inventor is claiming. So you might actually, even though you've publicly disclosed it or offered it for sale, you might actually be excluded from making your own product. But the second question is, well, what if I just keep it secret, like keep it a trade secret? Because you might be worried other countries will steal your invention, but you have to think of how will you keep it secret? Remember when I talked about trade secrets, you have to make sure that you keep whatever it is, that secret sauce for your product. You have to keep that secret. So you have to also make sure that no one else can get your secret or figure it out themselves. So just keeping it a trade secret doesn't necessarily stop others from being able to reverse engineer things. Well, let me check one more second if Emily. Okay, Emily has not messaged me. So now we're going to talk about trademarks and both the TM, so the common law trademark, and the circle R, the registered trademark. So common law trademarks, that's the TM, is created whenever you use the trademark in commerce. So you can use the optional TM, or if you have a service, the SM, which stands for service mark. This is limited to the geographic area where the mark is used. So for example, if you were a company that sold something in Colorado, and pretty much only in Colorado, you could use the TM, and it's automatic. You get a few rights with it. You're declaring that I'm using this as my trademark or as my signifier of where my goods and services come from my company, for example. You would never use the circle R. That's reserved if you've registered with the Patent and Trademark Office. And that is on the next slide, I believe. The circle R for federal registration requires you to register with the USPTO. That goes through a trademark examining attorney who determines whether or not someone else has used the same trademark name or phonetically sounding similar name for the same goods and services you want your trademark to be registered under. It gives you a legal presumption that you own the trademark. So you won't have to get into arguments like, no, I use this TM symbol from 10 years ago, and you have to prove that. The registration already gives you the presumption that you own that trademark. You don't have to prove that you own the trademark. The certificate says that you do. They also gives you the legal presumption to use the trademark in all 50 states and the U.S. territories. But remember, intellectual property rights are not necessarily transferable to other countries, or the fancy word is other jurisdictions. You can claim notice to the public on your rights to the trademark You can bring legal action considering trademarks in federal court. So say somebody else is selling a similar product and using your trademark to try to pretend that they're you, you can send them a letter saying, hey, you're violating my trademark, and even bring a suit against them to sue them to stop them from using or to sue for damages. This also, and this is the big one, enables recordation of registration with U.S. Customs and Border Protection. There is a program called Stop Fakes. I will have a slide on that in a little bit that talks about what Stop Fakes is, but it's basically a joint venture between the USPTO and the Customs and Border Protection, where the Customs and Border Protection gets a list of all the trademarks that are registered that the business has requested Customs and Border Patrol to look out for. They monitor incoming imports to see if anything has been violating those trademark registrations. So it can also be used as a base for filing in another country. So you can, through a series of agreements, can go file with other countries after you've gotten the trademark registration. You're also permitted to use the circle R, which is very tiny down here. I'm sure you've seen many things with trademarks with the circle R on them. So here's a list of a few advantages of the federal trademark registration. You have a public notice of claim of ownership. There's a legal presumption that you own it. You have ability to bring action in federal court. I've covered a lot of this. You have a legal right to use the circle R. This is listed on the online databases so other people know, hey, you already claimed this particular name or trademark. Perhaps you should find something else. And as mentioned before, you can record with Customs and Border Patrol. There is a fee associated with that, and it's $190 per international class of goods. Please don't ask me what that technically means because I'm not a trademark examiner, but generally it just means what category of goods or services. So is it soap or is it chocolate? So moving on to trade secrets. What is a trade secret? Remember I talked about how it's basically a secret. These are some very notoriously well-known trade secrets. So Coca-Cola's secret recipe, Krispy Kreme's like method of making those donuts really soft, and Google's algorithm is considered a trade secret. So people aren't allowed to know what it is. It's kept under lock and key. Here are a few ways you can lose a trade secret in case any of you do have trade secrets like secret recipes. You can fail to take adequate steps to prevent someone else from finding out or from one of your employees, for example, from telling. Or you could just tell other people, like if I remember correctly, KFC's recipe was just disclosed by one of the heirs a few years ago. Which is the owner authorized disclosure. Or you could have an employee that just spills the beans or have corporate espionage. Wow, we're getting exciting now, aren't we? Somebody could reverse engineer it. Oh, there's Emily. And you could have independent development. Emily, you want to take over? I'm on ways to lose a trade secret. I just finished that up. Nope, Emily's good. So moving on to copyrights. She has had extreme problems with WebEx the last 2 days. So as I mentioned before, copyrights are registered with the Library of Congress, but they are normally just created as soon as you create the copyrightable material in tangible form. Registration of copyright gives you a few more additional legal rights that you do not get just from having a similar creation like what the common law trademark is. So the term is offers life plus 70 years. If you want to know more information, you can go to the copyright.gov website. They actually have a very excellent series of primer videos on copyrights. Emily and I watched them on a slow day. It was very entertaining and very informative. So why should you care about copyrights? There's a couple of reasons. Mostly, almost everybody makes some type of copyrightable material, whether it's advertisements or a menu or a book or a recipe book. You'll see that later in my example. You can prevent knockoffs and you can protect your artistic works. So if you're wondering like, wow, this is a lot of information because there is a lot of different types of intellectual property or IP. We actually have something called an IP identifier. It helps you from a starting point as a novice, determine what type of IP you or your business might have. So you can go to ipidentifier.uspto.gov, or this lovely QR code should take you there. And it'll start off with a conversational type of question like, do you already know what you have, or are you starting from the beginning? You can learn some information about the types of IP you might have and get some additional information and links for helpful resources for the particular types of IP you might have. So we're going to take a break now from all this download of information, and we're going to do an exercise. So I think, should we let everyone unmute or a message? Sarah, what do you prefer?
Can we interrupt for a quick question too, Kathleen, before we
Yes.
move on? Frank is
Yeah,
wondering if
sure.
you can put the value of his IP on his balance sheet.
Okay. So we at the USPTO do not officially value IP on the balance sheet, but I am currently taking a private equity investing course, and there are different ways of valuing it, depending on the type of intellectual property. Sometimes it's valued at how much it would cost the company. This is in no way legal advice, but sometimes it is business advice. Sometimes it's valued on how much it would cost an acquirer to redevelop that intellectual property from scratch. So that, I don't know if that's a complete answer. It's very hard to evaluate IP just on a blanket statement. It's very much so case by case basis because it depends on the type of IP, how critical it is to your business. So, for example, a trademark that is as well known as Coca-Cola, for example, could be worth trillions of dollars, or a trademark for a side project that you have that's not really making that much money, maybe probably not worth that much on your balance sheet.
Right. Thanks, Kathleen. Do you want me to go ahead and unmute everyone?
Yes, we can do that. Feel free to shout out your answer. So I'm going to give you a premise of a fictional gluten-free pasta recipe company. So let's say you've developed a recipe for a gluten-free dried pasta. You sell at farmers markets and online all across the country. This is important. I didn't mention this during the trademark talk, but for a registered trademark, you do have to be selling in more than one state in order to qualify for a registered trademark with the USPTO. The caveat is you can be intending to sell in more than one state. So if you only have a boutique hotel in one state and you're never going to open up anywhere else other than that location, you probably don't qualify to get a registered federal trademark. But if you're in the situation, the pasta that you can mail to online to people across the country, you may or may not qualify for registered trademark. The pasta comes in a resealable bottle that's got a special shape, so everybody knows that that bottle is your pasta. You even invented a unique machine to cut, dry, and package the pasta. So you have what customers are saying is the best dried pasta they've ever tasted. And there's even a cookbook on ways to use your pasta and social media posts that gets customers excited to buy and use your pasta. So with all of this information about this business, this fictitious business, let's look at what type of intellectual property we might have. So what type of trade secrets do you think we might have in this pasta recipe? Feel free to shout out the answer. Make me feel like I actually got the information across correctly.
Ooh, a recipe.
The
Recipe,
bottle,
thank you, Emily. Not that Emily hasn't seen these answers already. The gluten-free recipe could be a trade secret.
what about the bottle?
The bottle? Is that a
Well,
trade secret? Can you keep the bottle shape secret?
can you well, I'm comparing it to like your Coke bottle, right?
Right, but trade secret has to be kept
No,
a secret. I'm going to give you a hint. I think that's the only answer for trade secret in this example. So what about a design patent?
Okay, I'm
Remember,
coming
the
back.
design patent is
My
the look and
bottle.
feel of something. bottle?
Yes. Woohoo.
Yeah. The special shape of the bottle. It's just the shape, not the mechanism to keep it fresh.
The colors, the print on the bottle.
Maybe I
logo?
haven't listed that in the answer, but yes. The special colors, if they're really recognizable. So think John Deere green or Caterpillar yellow.
I
Those
believe
are
those are,
very recognizable colors.
I think
And I
They're
those are
both
think
trademarked
trademarked.
and
I would like
patented.
to ask something else while since we're talking
Yes.
about that. I've worked with clients who had colors made. They use a certain type of color in their print, like a burgundy red type of print. Is that is that can be protected, right? If it's in their logo
Uh,
and
It can be, yes.
Yes.
With a trademark, those are special form of trademarks.
Mm.
And we say can be
Specifically,
because if
yeah,
someone else is
specifically.
already using that color for that
Mhm.
goods and services, then probably not. But if they are not,
For,
then
for
maybe.
instance, Barbie pink is a protected color. There is a special like um combination list that the trademarks has that lists what kind of pink would be created from those ingredients. So it's
The
kind of both
CMYK
yeah, it's
numbers.
kind of both like the paint, but also it's the hue as well.
Conversely, John Deere has a trademark on that green and yellow combination, and they have a patent on the chemical composition that creates that green color paint. But that's a very specific chemical composition to make that paint. So what about a utility patent? Remember, utility patents like how things work or chemical compositions for a very specific paint.
How about the
So
machinery to make the pasta?
yes, so we have machinery to make the pasta
Is
because
it?
it is a special machine,
But
not just
isn't
a
that
generic machine.
okay? I was gonna say if that machine, if you go to a
They
machine
invent
manufacturer and they just make machines, that's not patentable.
Right, and
correct.
it would need
So
to be more
it
so
has to be a
than
machine
just
they've
like a mixer.
right. It's got to be a machine that very special machine in this case that the company is the person's invented. That's new, useful, and non-obvious. If you want more specifics about that, you have to go ahead and ask Sarah to please have us do a patents basics course, and then we can go into more detail about all of that, what goes into utility patent. What about trademarks?
Logos.
Logos, yep. And then we even talked about like if there's special colors that identified, perhaps uh, the business name, the actual
Or
business name could be trademarkable, not just the logo with the shape and what have you. It could actually be the business name. So Coca-Cola, for example, has Coca-Cola, literally just the words trademarked, as well as a stylized Coca-Cola with the sweeps as a trademark. They have two different trademarks to provide
You
the
can
broadest
trademark a slogan
coverage.
too.
Yep, they have slogans as well that are trademarked. So company name, logo, or slogan. What about copyrights?
pictures, manuscript,
Pictures? Yep.
any
Even
form of
the social media posts you've been making, if you take pictures to be like, oh, look, I made this pasta dish. Take a picture, post on social media. That could be copyrightable.
right. So I have a question about that.
Mm-hmm.
So I'm a professional photographer, and is it enough for me to put like the symbol, the copyright symbol, the year, and my name on the picture to protect it, or do I have to go into the file information and put that information in to protect my picture?
So typically I've just seen the copyright symbol with the name and the year or vice versa. But I think if you wanted to know more information specifically about copyrights, you would go to the copyright.gov website because that's their specialty. So they also have something called registering with copyrights, where you register the copyrightable artwork with the Copyright Office for additional rights and legal presumptions. And it's my understanding that photographers specifically don't register one photo at a time. They have a collection of photos that they register all together as, like a book, as it were. But the Copyright Office at copyright.gov is probably the best bet to find out specifics on that.
Thank you.
So here's the answer. Any product pamphlets you have, commercials you've made, social media pictures, any cookbooks you developed that accompany the process. So note that recipes, specifically just recipes on their own, probably not copyrightable, which is why when you go to blogs that have recipes, they have all that whole long story about how their grandma used to work in a buttery place and make butter by hand before they get to the recipe. That's usually why. So they have some copyrightable material because it's in a longer form than just the recipe in and of itself. All right, thank you all for participating for that exercise. We're going to get back into the nitty gritty. So this is a overview of the patent process. This is probably one of the most involved intellectual property registration or application processes you're going to encounter. We use application because you're not guaranteed to get a patent just because you apply. You have to pass a certain level of requirements and laws. If you want to know more, again, ask Sarah for a patent basics course and we'll be happy to provide one. So a lot of it is actually in level 6, but you definitely need to determine what type of IP you have. So if you have an invention that's patentable, meaning it is something that could become a patent, so a machine, product, item manufacture, chemical composition, or improvements of any of the above, or methods, you might be able to determine what type of patent you need. There are 3 types of patents. We won't get into that detail now since this is an IP overview course. You would get ready to apply. So that means writing your application up, writing your specification to describe how your invention works or how to make it. You prepare and submit your initial application. And then at 6 is where a lot of the negotiation goes on. Your examiner, which would be somebody like Emily or I'm not guaranteeing it's going to come to us. We all specialize in specific technology areas. But you will often get a reply back from the examiner saying, no, you can't have a patent because this other person did this. And it looks really similar to it looks exactly like what you were saying. Or yes, you can have a patent. I haven't found anyone else who's done your idea. Congratulations. If it's a no, a lot of times there's a lot of back and forth in negotiation. And then 7, and this makes it very deceptively simple and short, you would receive your approval, which means you would be granted a patent. And then 8, you would maintain your patent. Again, patent has a term of how long you can have the patent for, but there are some fees involved in maintaining your patent after, I don't know the exact number of years because I don't do that part, but it's something like 4, 7, and 12 years. You have to pay a maintenance fee, basically saying, yes, I'm still using this patent. I would like to continue to have it as my property. So remember I talked about the stopfakes.gov program. It is a joint program with International Trade Administration, the Department of Commerce, meaning USPTO, and the Customs and Border Patrol. You can go to stopfakes.org.gov, and it will help any businesses in protecting and enforcing their IP rights against counterfeits and pirated goods. It has a lot more information than what I'm disclosing here. It provides a lot of guidance training for businesses, particularly small businesses, and you can do it by country of interest. So if you are importing or exporting and you're worried about fakes or pirated goods or counterfeits, you could probably will find a lot more information at stopfakes.gov. And as I mentioned before, with Customs and Border Protection, they do seize imported goods, which violate intellectual property rights in the United States. But remember, you have to have registration with the USPTO in order to be able to enroll into this program. And this is the fees involved with enrolling with the program if you already have registered copyrights or trademarks. So here is the fun stuff for researching. Here's all the resources we have available to small businesses and entrepreneurs. So we have a landing page for startups. It's uspto.gov/startups. You can see there's a variety of different topics that would be related to a startup business and what they might need. Some of these go to external links, but a lot of them are more geared towards patents and trademarks for startups. It might look a little bit different than this. Don't be surprised if it's not exactly like this page. We're doing a little bit of a website overhaul in the next couple of months. You can also file for a patent application on your own. And I believe you can also file for a trademark on your own. We call it pro se, which is Latin for yourself. We have a pro se assistance program for filing a patent application on your own. You can go to this website, which is a very long one, so I will not read it out loud. And it walks you through a lot of the process. It also has specialized examiners that can help you, that they're specially trained on understanding this perspective, a pro se applicant or small business, somebody who's not done this before, not done a patent application very many times will have. We also have a new patent search tool. So one of the recommended steps before you file a patent is to do a search to see if anyone else has done your invention. So it's called a patent public search. There is a welcome page. There are now two buttons. There's a basic search and a start search or advanced search. The advanced search very closely mimics what we as patent examiners use to search for what we call prior art. So other publications or other previously filed and published patent applications.
And we do recommend that if you are filing, please do search before you file. If you do happen to find it, it would save you a lot of money before you file than if you find
No.
if the examiner gets assigned. So just make sure that you do please do research before you decide to file.
Definitely. And I'll get to patent and trademark resource centers later, but they can help you learn how to search on the system or how to develop an effective search strategy. On the trademark side, we have the new trademark search system. It used to be called TESS, but TESS is retiring. You can go to, it's a beta version, but you can go to this link to use that system. And I believe the PTRCs can also help you on learning how to use this system and how to formulate an effective trademark search. So this might actually be most useful for a lot of businesses who are contemplating filing for a trademark or new names for products, that sort of thing. You can find all the federally registered trademarks of both current and both live and dead. So dead meaning they no longer use or have certified that they use it in commerce. And you can even see like all the really cool, like fancy trademarks that look like logos with all the pictures and fancy swirlies and such. So there's also resources in your area. You're probably already aware, but we have a regional office in Denver. That's the Rocky Mountain Regional Office. That's where we are working out of. But there's also other regional offices across the country. We also have, through headquarters, these additional resources. The Inventors Assistance Center, it is a 1-800 phone number, which I will have later, that you can call and ask basic questions about formalities, about the application process. We also have a patent pro bono program, which provides free or very low cost legal advice and help for filing your patent application. And paired with that, we have our law school clinics, which pair inventors with law school students who are supervised by a patent attorney or a patent agent that works at the law school. to write and help you apply for patent applications. That is also free or very low cost. Mind you, with these two programs, you as the inventor or the applicant will still need to pay the application fees for a patent application, but the legal advice itself is free or very, very low cost. I think some of them have been like a $25 registration fee type of low cost. And then, as I mentioned before, we have patent and trademark resource centers, which are specially certified libraries that can help with patent and trademarks. So as I mentioned before, we're the Rocky Mountain Regional Office. We're in downtown Denver. And we do provide advisory hours and tours. We also provide the Path to Patent series and trademarks basic boot camp, but it is recommended that you make an appointment if you did want to come into the office, because a lot of people are actually just working from home. So we need to know to be there. We can also do things virtually where we do one-on-one consultations. We can also access our free services. So we have a web page, and it does not look like this anymore. We have just updated it, but it has the same information where it's sorted by patents, trademarks, or if you need to find information about attorneys and business advisors, and you can filter by the area of interest. It should give you most of our free services that we provide or that are provided and coordinated by the USPTO. As I mentioned before, we have the Inventors Assistance Center. They have a pretty broad range of hours that they're available. They are staffed by former supervisory patent examiners and experienced former primary examiners. So, for example, if Emily and I were to retire and wanted to still do something, we would staff the Inventor Assistance Center. They can answer general questions about patent examining policy and procedure. They can't answer specific questions, but general questions they definitely can field. So we do have some upcoming programs. There's Path to Patent, and I apologize that this does not have the website. I thought I put it on, but it did not save. That is our quarterly series where every week we go through a different topic on how to get to applying for a patent and then what to do after you've gotten the patent, say you want international protection, and post-patent issuance procedures. We also have a trademark bootcamp, which is similar to the Path to Patent, where they provide you all the information you need to know to get you to the point where you can file or apply for a trademark for yourself. Here is a list of some federal funding sources. These are not through the USPTO because we don't actually provide funding to people, but you will notice that SBIR TABA, or TABA, which is the Technical and Business Assistance program, actually provides funding for small businesses to pursue their intellectual property protections. So that is some of the funds that can help pay for an attorney, for an example, or your application fees if you're granted this particular small business grant. And then on top of that, here's some suggested searches you can do for finding local funding. Since local funding tends to fluctuate pretty greatly throughout the years, we couldn't recommend any specific ones, but here's some ideas on how to search in your favorite search engine, since Google is actually a trademark. So we shouldn't be using Google as a adjective, but you can look for these to see what might be available locally, your specific town or city or state. One of the big ones might be social media influencers. A lot of them, especially small business geared ones, talk about the newest local grants that are being provided or pitch competitions, and they're very contemporaneous or timely. So here's a whole list. Don't worry, Sarah has the PDF of this with some of the resources we talked about. Some of the big ones would be the Pro Se Assistance and the Inventor and Entrepreneur resources.
And in the chat, I've posted the Path to a Patent link and the Trademark Bootcamps, Trademark Basics Bootcamp. Those should be available. I sent it to hosts and panelists. I hope everybody can see those.
All right, thank you. I hope I'm not, oh, I'm still sorry. Those are my kids. I don't have the most professional background.
Okay. Well, I'm going to thank you both. Awesome. Great information. And how old are your kids? They're young.
Oh, they're young. Yeah.
Yeah. Okay. I still have a picture of my daughters on my phone, and half of them don't even live home anymore.
They're
So
little, right? And they're like
they're little,
teenagers.
yeah. So I would like to thank you both. A lot of information, but before I let the everyone go, I'm going to let everyone know. I know Frank had a question that you all couldn't answer, and rightfully so. We're not attorneys, we're not CPAs, but I can tell everyone from being a business broker in a past life that everything that you have that's registered or patentable, any of those elements such as that will increase the value of your company. So those are things that do carry blue sky value, but you would need to talk to an attorney to figure out how that works. Also, if you're going after grants, one second. Also, if you're going after grants, right? You know what you're protecting within those grants, depending on the type of grant. They mentioned SBIR, STTR, maybe some OTAs out there, right? You have to protect yourself. You may have limited or very limited protection from the government itself if you're developing something with the government, right? But that all comes down to core IP and those kind of things that we could talk to you all about. But I just want to make sure that you all understand your logo, any of your proprietary information, all of those things, your ebooks that you may create, or any of those kind of elements do have value, but that value can only be substantiated if it's protected, if I may go so far. And with that, I'm going to open it one last time. If there's any questions, please ask them now. If not, you can send us an email afterwards, but I would like to give you back part of your day. And Sarah, if you can open up the line in case anyone has any questions.
Yeah, and actually, while we are waiting to see if anyone has any last questions, I'll ask Katie to come on. She is our partner with B-Side, and she's just going to give us an overview of what services they can provide to our small business owners on this webinar. Hi, Katie.
Hi, everybody. Sorry, I was unmuting. Can you see my screen?
Yes.
Great. Okay. So just to let you know, for the few that are on this call, B-Side Fund, we're a nonprofit lender here in the Denver metro area, serving the entire state of Colorado for small business financing. We also can help small businesses in the Four Corners, so Utah, New Mexico, and Arizona. And let me just click through a couple of screens for you. You know, we really are here to help small businesses when they can't get traditional bank financing. And so we're here to really help you grow and, you know, get to the next level that your business needs to get to. We have loans anywhere from $20,000 up to $350,000 and terms from 3 to 10 years. Our max interest rate right now is prime plus 4.5, and our programming does not have any prepayment penalties. So if your business is doing really well and you want to pay your loan down sooner than later, you are always more than welcome to do that. You can use our loan financing for a variety of uses, so working capital, equipment, inventory, to purchase another business or to refinance debt. And we do require that you provide a personal guarantee, you pledge all your business assets, and you contribute at least 10% of the loan amount to the project in total. And the application process is really easy. You just go to our website and start with our eligibility check, and that will see if you're a good fit for any of our programming. Then from there, we collect online document collection with a secure portal. We review everything, send it to our loan review committee, and then look for an approval, closing, and funding. So if we can't help you, we always have a good resource of partner lenders in the community. We've been doing this for 30 years, so we can always help share another lender that can help you if we're not able to. And yeah, you can find more resources. We have a lot of blog articles and more about our organization at bsidefund.org. But that's it for me.
Thank you, Katie. If we have any questions for anyone on the call, please feel free to unmute yourself and talk. Otherwise, I'm going to go ahead and stop the recording. And as Andre said, you will get a copy of the slides from both Katie and Kathleen and Emily after the webinar, as well as a recording of the webinar itself. And I think everyone is quiet. So with that, we'll go ahead and close out. Thank you, everyone. Appreciate it.
Thank you.